but then they've signed something and we don't know what it is they've signed. There's probably no legal requirement to do that. Consider installing video cameras and hanging. There are now devices, DVRs, that will save your video feed for up to 2 years. We've killed many cases because we had the video, and you can always tell a scout behaves differently than a true customer. We make some other suggestions, and I'll let you read those on your own. If you think there's a claim in process, sometimes you see someone taking pictures or measurements of your property. Sometimes you'll get letters from lawyers saying, hey, we saw a lawsuit was filed against you. Don't wait for the lawsuit to be handed to you. I would call a CASP immediately, because under the new law, if you're inspected before you're served, not before you're sued, but before you're served, you might get some special protections that we've actually eliminated a number of cases just because we qualified for these new protections that I'll tell you about. So in a situation like that, contact an attorney and a CASP immediately. You may have 10 days or less to get the benefits of the new law. Obviously doing it before, doing it now, go do it today, and then you definitely will have those benefits. If you're already involved in an ADA lawsuit, talk to your lawyer about whether a CASP or an ADA specialist could help you. Check with your lawyer before you make changes. If you do make any changes, work in progress pictures are extremely important. We talked about that. If you've previously been sued, it is important that you understand that there are a lot of people who comb the public records. They want the addresses of businesses that have been sued before in lawsuits, and they're going to come to your place and check, because now you've been on notice of non-compliance. So it's doubly important that you get a CASP inspection if you've ever been sued before. I talked about the new law. Since we're over time, I'm not going to go into the big, well, here's the biggest deal. Number one, if you get inspected before you're served with a lawsuit, if it's in state court, you may qualify for a 90-day stay of legal proceedings and an upfront meeting with the judge. I've had at least 3 cases drop off just because the plaintiff did not want to come to court. I think the plaintiff said to their lawyer, look, you can go get me some money, but I don't want to go to court. And so the cases just died. I can't guarantee you that yours will. On the other hand, it might be a lot easier to resolve. There are many benefits to CASP inspection. I'm not going to go through the details of those with you. There are many misconceptions about the new law. Let me just say this. There is no good reason for not being CASP inspected. If you retain the CASP through a lawyer that's representing you, then it's the attorney's work product privilege, and no one can get the report in a current or future claim against you. There's simply no good reason for not doing it.
Unless the person is designated as an expert. So how do you...
Well, tell you what, let me talk with you about that after the seminar. I still stand by my position that there is no good reason right now, if you don't have a lawsuit pending against you, there's no good reason for not getting inspected. If you have a lawsuit and you've been inspected, it's your choice as to whether you want that inspector to be your expert. You may or may not use them, but to me, the concern is if you don't know, if you don't have the information about what conditions at your property could trigger these lawsuits, you're more likely to be sued. So unequivocally, there is no good reason for anybody not being CASP inspected as long as you retain the CASP through an attorney. And all that means is they address the report to the attorney and they email the report to the attorney. The attorney can forward it directly to you. Okay, moving on. You may not, people think it's going to open a Pandora's box. As long as you retain a CASP through an attorney, it generally won't. You may not need to make all the changes that a CASP suggests. You may want to exclude non-public areas from the report. And remember, you don't need to be, some people think they need to be certified as compliant by the CASP to get the benefits. You don't. You only need to be inspected. And if you're inspected, if you're sued 20 years from now, you could, if the law doesn't change, you could still get the benefits of the law.
Why do you have to get it through an attorney?
I'm sorry?
Why do you have to get it through an attorney?
Well, because if you retain the CASP directly, someone suing you can get that report and even compel the CASP to testify against you. If your attorney gets it, it's just like if I hire a private investigator, someone suing you can't get.
Got it.
Okay, you get it. They're my expert then. Okay. What are the benefits we talked about? I'm going to have to gloss through this. Many people think they've been served and they're wrong, even if you're handed papers. A lot of times we see service done improperly. The reason, I'm not suggesting that means you can forget about a lawsuit, but it might mean you still have time to get CASP inspected. And to be honest, we've gotten a number of these early evaluation conferences for people who were handed papers, but it wasn't done right. So once again, the minute you have a clue that you might be sued, if not sooner, consider getting a CASP inspection. All right, moving on. Oh, this is very important, actually. You need to get a written report. It needs to have a timeline for making changes. If you don't get a written report, if the CASP just comes through and makes some verbal comments, you may not qualify for the benefit. I point out that other countries and cultures don't use a lawsuit-based system. My personal belief is that it is crazy to think that a system of private lawsuits is going to change building standards when we see there are many better ways to do it in other countries and cultures. There's a group in Sacramento that seems to think that if we only had enough lawyers and we only had enough lawsuits, California would be perfect. And all I see are that businesses close and jobs are lost. I think it's insane. But I always like to show people this poster. I was in London in early 2004. These were all over the bus stops. You couldn't walk a couple of blocks without seeing one of these. Other countries give you notice. Other countries post clear lists. California keeps changing the standards. California likes gotcha lawsuits. You should be talking to Marianne Maloney, Senator Dutton. They know. You don't have to convince them. But the reason this is going on, I am up in Sacramento. Sometimes I'm the only person in the auditorium while these people are thinking of new standards and new ways to change the game. They will listen to you. I talk to people in Sacramento, they tell me, we haven't heard a thing from our constituents. We had no idea there was a problem, whether that's true or not. They need to be hearing from you, unless you think this is a great way to run a state. You can even see the votes against the reforms. Just do a YouTube search for SB 783, you'll see Senator Dutton on those, and you'll see the legislators who voted against those. I do want to point out, and we are at the end, since I'm way over time, I'm going to go through these very quickly. There are some things that a CASP inspection report probably won't tell you that could lead to claims against you. This is a relatively small group of claims, but I think you need to know. There are a growing number of website claims. What I'm talking about, everybody's got websites now. The basis of the claim is that someone who uses screen reading software because they're either blind or visually impaired, it reads things out on the screen and it helps them navigate the internet. That your website may not be compatible with that. And I'll give you an example to show you what I mean. The program is called JAWS for Windows. Pardon me. Let's say you've got 3 products here, all right? Now you've got a picture of a blue sweater, but if someone has no visual skills at all, they don't know that. All they see is $49.95. They have no idea what you're offering. The simple solution is to do the best you can to explain it's a men's blue V-neck pullover sweater. Some people consider that unsightly, so look what I did over here. I put the text in almost the same color as the background. You can have the text in exactly the same color as the background or even as the image, so it's invisible, but it will be read by a piece of screen reading software, and it will read that out, and they can decide if they want to purchase it or not. There are a number of resources for making your website accessible. Inquiry calls. This is very important for 2 reasons. Number one, I know this from my own family. If we just wanted to take my stepmom out for Mother's Day, we need to know if the place is going to be compliant. If she's going to be embarrassed because the aisles are too narrow, we would rather just go someplace else. Your people who answer the phone may get questions about what accessible facilities you have. I would suggest have a statement prepared in advance that they can read. Don't have them try to figure it out and give half an answer when someone calls on the phone. Also, slurred speech. Some people hang up because they think it's a prank or that they think someone's drunk. The fact is, some people cannot speak clearly. In a situation like that, I would say, can you dial 711? It's a free service. An operator will call back with someone on the line that can assist with communication. There are other things you can do, but that needs to be in your policy that your employees sign off on, that you provide assistance to people with disabilities. Policies and procedures always seem to be the last resort. That when plaintiffs' counsel worked there, we had a case, again, 17 months, all the claims were false. What they always do is they say, well, you didn't have a policy and procedure for assisting people with disabilities, and so I'm going to prevail on that. Well, have a policy and procedure. Have your employees sign off on it, have them initial it periodically and keep copies of that. Service animals. This is a biggie under the 2010 standards. If you go to ada.gov, you will hear that only dogs and miniature horses are approved as service animals anymore. In California, that may not be the case. You may have read in the LA Times about a group that was lending Rottweilers to the homeless to make service animal claims. You need to know what you can do, what you can't do. Your employees need to know. You don't want to figure it out as a dog walks through the door. But I do want to be clear, there is generally no requirement for a vest or medallion. There is no requirement for documentation. In California, companionship may be sufficient. If it impairs your business or creates a security risk, there may be relief, but that's a very narrow claim, and we would want to talk about that after the presentation. Visual limitations, everybody has word processors now. If you're asked to put something in large print, certainly menus, you want to be sure you have large print menus available. But if someone asks you for a document in large print, I would say the answer should always be yes. Tactile markings, an example of that would be if someone was blind and they went to a pharmacist and they need their medication marked in a certain way. Once again, the answer should be yes. You should find a way to do it. If someone asks you for taped text, what they're talking about is you just need a staff member to clearly and slowly read a document onto a tape cassette. That doesn't apply to many businesses, but someone can't read a contract, they may need taped text. Once again, the answer could probably be yes. Braille considerations, we talked about that, but I do want to point out, you can get a $20 labeler and you'd be shocked at how cheap, especially if you have automated devices that have instructions on them, you'd be shocked at how cheap you can buy some of those signs on the internet. Remember, some people have hearing limitations. There may be things you can do. Your staff needs to be sensitive to this and consider writing out, may I take your order, or whatever it's going to be. Yelling at someone can be humiliating. Especially in public. We talked about slurred speech. There's some suggestions for dealing with it. You may be asked about adaptive devices and auxiliary aids. Once again, have a policy if that's appropriate for your business. Now with that, I just want to say thank you for your attention. I apologize that we ran over a little bit. At this point, I'm happy. In fact, Philippe, would you come up, because the odds are we're going to have some technical questions.
Yeah, and if anyone needs to go, I can give you a card and you can email me questions, and that's fine.
Do you have any general comments that you'd like to add?
Yes. You all have a target on you. I've seen lawsuits that range a lot of what David sees, everything from a mere that is a half of an inch too high in a dressing room where the bottom of the mirror, you know, has certain height requirements. The smallest thing, so no detail goes overlooked. You can't just use a term called construction tolerances and assume, well, it's close enough, it's okay. That's why a lot of building inspectors sign off on a building, because they're used to looking at things that are pretty close, and according to you know, industry standards or construction tolerances, they say, oh, it's fine, you know, we'll let it go. With these kinds of lawsuits, that's never the case. I've seen things literally as close as a half of an inch or less if it's a threshold or something. An important concept is that barrier removal, which is the term that is used to increase access by removing something that would be considered a barrier to somebody with a disability. That would be the doorknobs, the thresholds, the heavy doors, parking spaces, curbs, whatever that is. Those are all barriers to access by somebody with mobility or vision disabilities. And barrier removal is an ongoing responsibility. That means, sadly, unlike the building codes, that if something changes, you have to try and comply with it. For example, nearly every Coke machine, Pepsi machine in the state, in the country, is going to be rendered inaccessible after March 15th, because, as David mentioned, the highest operable part where you put the dollar bill in used to be 54 inches. And many of them, most of them, are still at 54 inches. That's all now been lowered to 48 inches. I do work with a lot of banks. They have to go through and lower all their ATM machines, or at least, you know, a proper ratio of ATMs need to be lowered to no more than 48 inches. Now, a bank, you could argue, oh, they have the money. So they have the means. I'm just a little guy. I own a convenience shop, a convenience store. Convenience stores are probably the toughest, because you try and pack so many things into. Anybody have a convenience store here? Little grocery store, anything like that? Okay, they're really tough. If you ever go into those and you're walking down the aisles, you know how much merchandise they try and fit in there, and it's very difficult. But let's see, hotels. I know we have some people from hotels here. Starting on the 15th, you better have a permanently installed pool lift at the pools and the spas. Portable ones are no longer considered acceptable. They want permanently installed pool lifts now. You know that, okay? And let's see, what else did I want to add to it? Yes, as David pointed out, the number one thing when people drive by, if you have the exterior of your building where it shows that you have done your due diligence and you have made your exterior at least compliant, they will probably move on to another person's business. If you haven't done anything to the outside of your property, you're an easy mark, and all they have to do is drive down a street and see. And if you haven't even bothered to restripe or to install a disabled parking space, you're going to get nailed. So since we're running out of time, I wanted to answer any specific questions if anybody has one. Yes, sir.
Does this apply to landlords that have apartments for residential?
Yes, if they have a manager's office on site, absolutely. You may drive in to rent a place, so you have the manager's office or sales office, leasing office has to be accessible, as does the common areas, because you don't know, somebody may rent a place and the kid has a birthday party at the pool. And it's not applying to condominium complexes, but apartments, it does apply. If the kid invites a friend who's in a wheelchair and they can't get to the pool, you've now discriminated against them. So the common areas do. Depends on the apartment buildings. They should have a certain number of units that are accessible, even if they're older units. You know, you can fix the landing so that a unit can be made into an accessible unit. So yes, it does. Yes?
Two questions.
By
One,
the way,
why?
just to follow up on Philippe's comment, this seminar is about Title III claims, basically against businesses. You raise an interesting question. There are some exceptions, and I can't give you proper advice on what those exceptions are. As a general rule, I agree with Philippe, but I know there are some exceptions, so I would say talk to an ADA defense lawyer to
check
sure.
the actual.
Go ahead.
Okay,
I don't, two questions. One would be for, I guess, Senator Dutton. Why can't the state, and I've talked to you about this extensively, why can't the state identify somebody who's actually like a fire marshal who comes in and inspects your, instead of doing this in conjunction with a 90-day notice, if we had a regulatory person like the fire marshal who comes in and tells us, you know what, you gotta fix this, this, and this, why can't we have something like that?
What they did back in 2008, they did pass a law that was supposed to set up exactly that type of scenario, where you actually can have somebody who was certified to approve your process. The problem was with that law, that would only help you provide defenses for when you get sued. It doesn't stop. What I'm trying to do is give you the opportunity to get it fixed, because we've had businesses now that have gone through that process. It's actually been in Redlands. I got a case where they actually did hire somebody to certify the business, and they still got threatened because there was some technicality that was missed. So the problem with that law is it didn't fix the problem, and this is different in the sense that I'm trying to provide a safe harbor for you to be able to address those things. And that is one of the problems with the law, because it may help you to provide a defense, but it doesn't guarantee that somebody isn't going to sue you.
But then again, in California, they can sue you for anything anyway.
Sure.
Even if you are compliant.
I think the question, maybe to put it a little better, one of the complaints or the feedback we get is that people say, I didn't know. I just didn't know that we had to do this. So perhaps, as you probably get as a business owner, all sorts of notifications about paying your sales and use tax, about new signs for employment, all that other stuff. The state, which is good at anything that relates to them collecting money from you, they're very good about telling you about that, but they should also send out notifications saying, look, even if you haven't changed your place in 20 years, you need to comply, and you run the risk of getting sued, and make people aware of it. I think that's a big problem.
The other
A lot of
question
people aren't
would
aware.
be, is California is much more stringent and strict on these laws, right, as opposed to other states?
Californians love to have, they like the right to sue.
Right,
We're a
exactly.
sue-happy state.
So basically what we're saying, in California, what we're saying is that the disabled people of, the Midwest are not as.
That's true.
It's
They have to file a complaint with the Department of Justice, and the Department of Justice can sue the business, and the plaintiff doesn't get much money. In California, it's set up where they get money.
That doesn't make sense.
California has a unique law, that allows attorneys or individuals to act in the same capacity as the state as far as litigation. We're one of 4 or 5, maybe 6 states that allows that. That's the reason why we have a tendency to be more sue-happy than most.
And that's probably why most businesses are leaving California. If they were the ones.
We've actually tried to fix that law, because that's another one's been abused.
Right.
There was a Trevor Law Group back in Texas that came into California, started working on action. We have individuals. I know of a couple of cases right now. ABC's done a lot of big story on it. We've actually had members of the disabled community that are out there taking advantage. They are angry. They are mad as far as they're concerned. Ignorance is no excuse. It's a civil rights issue for them. That's the way they look at it. You're going to pay me because you have inconvenienced me.
So I could probably go into someplace and as a short person, because I can't reach a book, I could probably.
You have some drive-by.
You have to be a qualified plaintiff. You have to actually show that you have a disability, but it could be a hip replacement.
But I'm disabled because I'm fairly short.
ABC did a story about a gentleman.
Are you less than 5 feet?
ABC did a story on a gentleman that was paraplegic in a wheelchair. He had actually, and frankly, there was a couple of attorneys that decided to represent the business on a pro bono basis. And the case ended up going to court. The attorneys were defending the business for it. They found in favor of the defendant. In this case here, the judge did. They ordered the plaintiff, the disabled individual, to pay restitution of $5,000 to the business. Refused to do it. The judge threw him in jail. And here's the reason why. Because they found out that over the last year he collected over $160,000 in fraudulent claims against businesses all over Southern California. The judge got pissed. The guy was thrown in jail. He made the restitution and paid, got out of jail. ABC asked him and says, well, now has this taught you anything? No, I'm going to go out there and go after protect the rights of the disabled. He's going to continue right on what he was doing. Later on, there was a little caption in the program was that apparently this person's also an illegal immigrant, and so now ICE is after him to deport him. Okay, but you've got career
Oh, yeah, we know.
people out there that are doing this, and it's because of the uniqueness of the California law that allows, I think they call it a personal private interest or
Private right of action.
private right of action, and that's unique in California, well, not just California, there's about 4 or 5 states that have the same problem. That's the reason why we seem to have a higher percentage of these types of lawsuits, than, at least that's what I'm being told. And that's the reason why a safe harbor, like what I proposed in this bill, would make some sense, because of the little frivolous lawsuits that you're gonna get confronted with. At least now, instead of paying the extortion money of $2,000 to $3,000, why not go ahead and take care of raising the mirror or lowering the mirror, repainting the striping, or, you know, let's try to get rid of those minor little things. I don't think that anybody deserves to be punished because the paint on the parking area has faded.
My claimant was disabled by committing armed
And
robbery.
Well, that's another
That's how he became disabled when he got shot, so.
You guys said who had a question over here?
You gave us a minimum height or a maximum height for mirrors in
Yes.
restrooms. Are the restrooms required to have mirrors?
No.
No, okay.
If you have it, there needs to be.
Okay, yeah, we actually don't.
And you can have 2, as long as one is at the correct height. Now, here's another tip. When you're going, if you go online and you download the regulations either from the state or the ADA, and it says a maximum height of, or a minimum height of, whenever there's a range, like a maximum, that means it can be no more than, say, 40 inches. Give yourself a margin. Put it at 38 or 39. Don't try and nail it at 40. A paper towel dispenser that has the operable part that can be no more than 40 inches, do it at 38 inches. That way no one can, you know, hide the measure or hold the measuring tape just so and take a picture at an angle to say, well, it was at 40 1/4 and therefore you discriminated against me. So give yourself some room when you're doing stuff like that. Yes?
I have 2 questions. Walkways,
Mhm.
how wide do they have to be outside flat paved walkways?
Typically 48 inches. If cars park up to that, just like in David's example, if the walkway is less than 6 feet wide, you need to have car stoppers, the concrete stoppers. If the sidewalk is 6 feet or more, you don't need those car stoppers.
What about across landscaping,
4 feet in California,
4 feet.
48 inches.
even if it's flat?
And not including the curb. You're not supposed to measure the actual curb. It's within the curb.
And then the second question is, when are you required to have an ADA accessible bathroom?
20 years ago.
Yeah, if you have a bathroom,
If you have a bathroom, right? If you don't have a bathroom?
if you have a bathroom that's available to the public, now the problem a lot of people make is they have a restroom in the back of their shop, and they are kind, and someone comes in, it's like, oh, can I use your bathroom? You say, yeah, it's back there, and it's not accessible. And there are people who, like David said, are scouts, and they will go in and say, well, you'll offer that bathroom to an able-bodied person, but not a disabled person. So if you have a bathroom like that that's in the back, that's not intended for your customers, like in a restaurant, nobody, no public, it's not available to the public.
But
By
you have
the
to have a
way,
bathroom though?
Not in all businesses.
I need to add to that under California law, there actually is a provision, it's health and safety code, well, it's in the materials, that says that if you have a restroom, even if it's just for your employees to use, it needs to be accessible to people with disabilities, the thought being that it could prevent someone with disabilities from applying for work at your business.
No grandfather clause or anything?
None. So, I don't see that provision enforced in Southern California as much as I do up north, but we figure it's only a matter of time, so it's better that you know about it now to plan. Sorry.
Yeah, and one of your employees may become disabled.
Yeah.
It happens, sadly, but it does, again, somebody could go skiing and end up in a wheelchair, even if it's for a temporary period of time. Now, all of a sudden, can they go to work for 8 hours if they